We're talking to Ms. Amber Gooden, and the topic is the Tennessee Human Rights Commission. And of course, Ms. Gooden, let's give you an opportunity to talk about some aspects of the Tennessee Human Rights Commission. And as we indicated earlier, when we introduced you, we said that you were the executive director. And so give us sort of an overview of the organizational structure of the Tennessee Human Rights Commission and how that structure sort of fits into the Civil Rights Act of 1964.
Okay. I'd be glad to. Here in Tennessee, we have 15 board members, commissioners, that are appointed by the governor of the state. 5 represent each grand division. So 5 out of West Tennessee, 5 out of Middle, 5 out of East Tennessee that are on 6-year staggered terms. In this area, for instance, some of our board members, our chairman is here in Middle Tennessee, Mr. Spencer Wiggins. Other board members, Dr. Joseph Walker just came on our board, Stacey Garrett, who's an attorney here, and so forth. We are very pleased to have the Reverend Billy Kiles, head of Operation Push out of Memphis, and very instrumental, as people know through documentaries, was right there when Dr. Martin Luther King was killed. So we enjoy the legacy of having great board members like that. The board then turns around and formally hires the executive director. And from there, the executive director oversees the staff. We have 4 offices across the state: Nashville, Memphis, Chattanooga, Knoxville, and Memphis. We have a staff of about 30. Most of those on staff are investigators. Those are the people who get the complaints and investigate them, review them, and make a recommendation to the commission to act upon them. We have 3 people on our legal staff. So we have in-house counsel that reviews them. I want to give people also a sense of in terms of the level of review that takes place, because sometimes people just think that they're just people out there working independently, and they want to say, well, that investigator was biased, and that investigator
didn't
like.
Do you have that as a charge?
Yeah, well, sometimes we have that happen. Sometimes we have a very diverse staff. We have 2 people of Hispanic descent on our staff, one of Czechoslovakian nature, 2 people from Africa. And sometimes that with that diversity, people sometimes think that because someone maybe doesn't talk like them or look like them, that maybe somehow that they aren't equipped to understand their situation. But our investigators are fact finders. Their job is to gather the information, is to review the witnesses, to interview what we call the respondent. That's usually the company in which the person has waged a complaint against, and then to make a recommendation. And that recommendation is reviewed by our legal staff, and then it is reviewed ultimately by me, and as well as then a final recommendation or information is given to the board. But it's also reviewed back by the federal agencies. All of our information goes back to EEOC, and all of it goes to HUD. And then their folks look at it.
And so, if there's some bias in terms of your evaluation of a case, then there's a possibility that you can be overruled. Is that what we're saying?
Well, definitely. It's to make sure that there are a lot of eyes looking at things to make sure we've covered all aspects of the law. I will say that I have not seen in the year and a half that I've been there, and I hadn't really heard it before, where really an investigator has an opportunity to have a bias, because you have to look at things in the strict letter of the law. So when somebody files a complaint, what they do is that they fill out a complaint form. They can call our office, go to our website, have one mailed to them, and that information is taken down. They're going to list witnesses, things like that, and then we're going to send out a formal letter to that company, or let's say, or to that landlord in the case of housing or something like that, for them
from your office,
from our office. And many times when I have spoken at forums, I spoke at one in Jackson not long ago, in which there were a number of employers there who were talking about the cost of diversity. And one of the things I spoke about was that when companies don't put in an internal complaint process in, by the time when somebody files a complaint with us, they're having to spend a lot of money, because they have to, by law, answer that charge. They can't look at it and say, oh, that's forget it. By the time it gets to us, they've got to answer it. And we have mediated a number of cases, which is a real strong program that we have with us, where people aren't necessarily admitting guilt, but where the parties want to get together and work it out. And you would be surprised that sometimes that it has only taken an apology from a supervisor to somebody, that a misunderstanding. So not everything results in monetary damages and so forth, but many times through mediation. And what I find when I speak so passionately about that is that I think many times that people have forgotten how to sit down and talk and listen. I'm not trying to talk us out of a job per se, but at the same time, we are there to try to get the best for both parties and involved. And so it's interesting that many times that's all it is. Sometimes people misunderstood a comment that someone made, but at the same time, we are also there to deal with very serious issues. One of those very serious issues that we see on the rise is in the area of sexual harassment.
Okay, very good.
Race-based complaints still probably outnumber all of them, but sexual harassment complaints are on the rise.
Now, what's your definition of sexual harassment in terms of the Tennessee Human Rights Commission?
Well, in most companies, I haven't found one who does not have some type of policy out there, but it usually what it entails is where someone that comments have been made or gestures and so forth that have made that person feel uncomfortable. They have expressed that, and it still continues and so forth. A case that's already been settled some time ago, but a good one, was where the person filed a complaint with her employer that a person she felt was harassing her, would call her, things like that, try to corner her outside the workplace, things like that. The company responded by making that person her boss. That was such an inappropriate...
Was that the way they wanted to respond, or were they trying to deliver a message?
It's not real clear. Sometimes people, I have to say, are just ignorant. And many times that, I think this was in a manufacturing situation, very few women, so to speak. And that sometimes people just don't know that instead of taking it lightly, they responded in a frivolous manner, but that was considered retaliation because she filed a complaint and she had a right to have that complaint investigated. It was responded back with essentially as if we don't think there's any merit to that. Well, if that person was made her boss, that person essentially accosted her and so forth, and she filed a complaint, and it resulted in a very sizable settlement on her behalf.
And of course, we've got about 2.5 minutes. Let's look at, and since you mentioned monetary settlements, are you at liberty to talk about some of these monetary settlements? What has been the highest monetary settlement that you've had in your administration?
In my administration, I believe it was that one, and that was over close to 100,000.
So you actually have complaints that are monetary complaints that will draw a fine of at least $100,000.
Well, and that was an agreement. That was an agreement instead of going to court that the parties agreed upon. She had her job back. The other person was fired. You have to look at things in terms of damages and so forth, and what action a company has taken to try to rectify a situation. Not everything results in, when we see on the news these big, $100 million, types of awards. I always try to caution people, and we also try to make sure that we are not lawyers for either party. What we try to do is we have attorneys who are there for the commission and try to advise what was in the best interest, hopefully. Fairness, exactly. And what's fair in one situation may not be fair in another. So we always, try to get people to look at what their own circumstance and what their own goal is. Some people have accepted, for instance, that in a case that involved a handicapped individual, instead of the person giving him money, he wanted money donated to an agency that trains seeing eye dogs. And that was reward enough for him.
So that was his reward.
Exactly.
Okay, we've got about 54 seconds.
Sure.
Let's have you to make some final statements in reference to that within the last 50 seconds.
Well, thank you. I'd just like to close with that the whole purpose and the reason that the Tennessee Human Rights Commission was ever enacted came out of the federal 1964 Civil Rights Act. And that was to allow people an opportunity to have their issues and complaints heard on a state level and to seek relief and so forth. Racism is still there. Many times people don't like to think that it is, but it's there. It's growing, especially in the areas of housing as our population becomes more diverse. And there are ways in which we need to educate and eradicate
and very
this.
good. And of course, Ms. Gooden, we apologize for having to call an end to this, but let me encourage our audience to tune in again next week for another informative edition of Comments. Thank you and good morning.